Chris Troupis. Chris is a friend of mine from my days in Idaho, and Chris is a candidate this year for the Attorney General's slot in the state of Idaho. The campaign, or the primaries are what I'm looking for, in Idaho will be held on May 20th, so that's coming up. So the campaign is heating up there. And I've invited Chris to come on as a candidate for the Attorney General's slot in the state of Idaho. He's running against the incumbent there. But I've invited Chris on to talk as a prospective Attorney General for the state of Idaho, kind of his assessment, his breakdown of the judge's ruling yesterday in federal court about Idaho's marriage amendment. Chris, great to talk to you again, my friend. Welcome to Focal Point with Brian Fisher.
Well, Brian, thank you so much. It's been a long time, and like I said, one of these days Maureen and I have to get down and visit you and Deb. We've missed you an awful lot, but love hearing you on the radio. So thank you for having me on the program.
Well, you know, Chris, one of my favorite memories, this is one of my all-time favorite memories in my whole life. Chris represented us. We had no money, our Keep the Commandments Coalition. We had no money. Chris was so gracious to represent our effort to protect this Ten Commandments monument in the city of Boise in a city park. And by the way, just got a text from Debbie, Chris. She wants to say hi, so pass along a greeting to her and greet Maureen for both of us. You know, the city pulled the Ten Commandments monument out of Julia Davis Park, and so we went about the business of collecting signatures to get an initiative on the ballot so the citizens of Boise could vote on whether they wanted to return or put a brand new monument up in Julia Davis Park. And you were the attorney that represented, because the city of Boise tried to block us. They tried to interfere with our right even to get a vote on this, despite the fact we did everything according to Hoyle. And, you know, the Idaho Constitution, Chris, it says, I mean, front end, all political power is inherent in the people. I think that's pretty much a quote, right?
Exactly.
All political power is inherent in the people.
That's right.
You know, the implication of that, of course, is, you know, that if all political power is inherent in the right to the people, then if you got an initiative provision that gives the people the right to vote, then that's a pretty sacred right in the state of Idaho. And now, Chris, do you remember when so you made your arguments? I think you went first.
Yes, I did.
Then the attorney for the city of Boise got up.
Right.
And she started into her spiel, and the Chief Justice of the Supreme Court, Dan Eisman, he just interrupted her, and he leaned over the bench, and he stared right at the attorney for the city of Boise. And do you remember what he said to her?
No, I can't remember.
What he said to her. You remember him leaning across the bench there?
I remember that.
Man, he got right up in her grill. He just interrupted her 30 seconds into her spiel, and he said, I forget her name, but Miss somebody.
I can't remember.
He said, Miss Jackson, is all political power inherent in the people, yes or no? And she was just she was stumped. She was stunned.
She didn't know.
She had no idea what to say. Because, you know, if she says, yes, all political power is inherent in the people, then what are you doing in here trying to keep them from exercising their will? If she says, well, no, then what are you doing in here defying the plain language of the Constitution? So we knew it wasn't going to be a good day for her from that moment.
No, and it wasn't. It was a smackdown.
Yeah, you want a huge victory for the cause of all that's good and holy and just and right on that day. And I know that's one of the things that went on your website, and that's one of the parts of your resume there that you're citing as a reason people ought to think about elevating you to the position of Attorney General. But Chris, let's talk for a minute about this ruling from this federal judge, Candy Dale.
Candy Dale. She's actually a magistrate judge.
Magistrate, yeah.
And which is interesting because you'd think that in a case of this kind of constitutional magnitude, that the state of Idaho would have insisted that this go before an Article III judge appointed by the president with the consent of the Senate. And yet they all consented to a magistrate judge issuing a decision that has, in effect, struck down our constitutional amendment defining marriage.
So this, this would look suspiciously, Chris, to me, like judge shopping. They find a judge they know is going to be sympathetic to their cause, and then the other judges in this district or whatever, they're complicit in it because they signed off on it. But you're saying this is very unusual to hand a decision of this magnitude to a judge at such a low level in the federal system.
Well, yeah, the magistrates are appointed. They are not elected. So, and they're not an Article III judge. They don't have life tenure. They are not constitutionally appointed, and so you have to consent to their jurisdiction. And in this case, the state of Idaho and the Attorney General's office separately consented that Candy Dale could hear the case.
You're kidding me. So what you're saying, this wasn't a matter of the judges in this district deciding this. The state of Idaho consented to have a magistrate, which is a bottom-tier judge, consented to let a lower-tier judge make this ruling?
Absolutely.
Oh, my gosh.
And that just, to me, it would seem to me that that's just so unusual. I would want to make sure that the person that's responsible for this decision be a person who was appointed by the president and approved by the Senate, so that at least for the political fallout, that it is an Article III judge that did this. Otherwise, you're talking about someone who's just was appointed locally to the bench, basically, as a magistrate.
Now, I know the governor has indicated his intentions to appeal this, and I understand, if I'm right, Chris, this will be appealed directly to the Ninth Circuit Court of Appeals.
Well, it should. All cases generally go to the Ninth Circuit Court of Appeals. There has actually been some talk, and I haven't confirmed this. I read the motion. They actually filed a motion for a stay on a contingent basis the day before the decision was entered. So they probably anticipated it. That's simply speculation on my part, or maybe it was just being proactive. In that motion, they said that they wanted to appeal they were intending to appeal to the Ninth Circuit. But what I've heard is that the governor's office is saying they may ask for a special appeal directly to the United States Supreme Court, which I'm not certain that's available unless the Supreme Court were to take the case, and I don't see that really happening.
Now, so I'm assuming, Chris, then that the current Attorney General, Lawrence Wasden, he would have been a party to that decision to let this magistrate handle it?
He intervened. The case was originally brought against the governor and the county clerk, who refused to issue marriage licenses. So then the Attorney General filed a motion to intervene and joined in the case. So the Attorney General was present and the Governor's Council was separately present, and both of them filed motions in the case. The case was decided on summary judgment.
Wow. So, if I'm in Idaho and I'm looking for an Attorney General to kind of represent me, I got to tell you, Chrissy, I didn't know this until just talking to you right now. I mean, I knew she was a magistrate. I didn't really understand kind of the ranking and hierarchy and all that. But if I was a citizen in Idaho, I would be appalled that the chief attorney in the state of Idaho, dealing with the Constitution, I mean, a lot of good citizens put a lot of effort and time and energy into getting that thing into the state constitution, that he would consent to something like that. That just seems to be an appalling dereliction of duty.
Well, I don't know. I certainly question it. But there's something even worse that I question, and that is the Attorney General chose not to personally appear in this case and argue it. He instead sent one of his subordinates to argue the case. And so, here we have the defense of our constitutional rights. And, the way I view it, from my experience, Brian, that when we were in the Ten Commandments case, I wouldn't have given that argument to anybody else for any amount of money or any kind of favor. I wanted to argue that case because it represented very important constitutional issues of religious freedom, issues that strike at the very core of our values. Well, I think in a case like this, if I am elected Attorney General, I would think the people want their elected Attorney General to be their advocate in a case defending the Constitution.
Well, it certainly, I certainly raise questions, and I appreciate your desire to be civil and decorous and all that kind of stuff. But to me, Chris, I mean, I'm just kind of agitated here listening to this. I mean, it would seem to raise questions in my mind about the Idaho's Attorney General, how much he even cares about the institution of marriage if he sends a subordinate out to defend it, and how much he cares about the Constitution of the state. He took an oath to defend this thing, and he sends us basically a lackey out there to defend this all-out assault on the supreme law of the state of Idaho. I mean, that just seems again to be another example of an appalling dereliction of duty. Pardon my French.
The last part of this is that the decision in this case is unusual in comparison with those in all of the other cases. You know, we have 10 other states that have basically gotten their laws struck down. Idaho's is a constitutional amendment, but what makes this really troubling is that this judge said that the Idaho ban would have failed any constitutional test. That is either heightened scrutiny or even rational basis, the lowest level of constitutional test, because she said in her decision the state has not offered any valid reasons to justify it.
Well, you know,
I can't imagine the state being unable to come up with a valid reason to justify a constitutional amendment passed by a majority of the people, two-thirds, that said that two-thirds of the legislature and a majority of the people that says marriage is defined as being between a man and a woman. I can't imagine being unable to present any valid argument.
You know, I remember, Chris, when back in 2006, when we were presenting the amendment to the legislature, I had a conversation with Mr. Wazen in the state capitol. I showed him the language of the amendment and asked him, how would you defend this? And he said, I don't know. And apparently he didn't know in 2006, and apparently he still doesn't know, at least according to this magistrate. My guest has been Chris Troupis, candidate for Attorney General in the state of Idaho, primary on May 20. Thank you, Chris. I had a Marine, and God bless you, my friend.
Hey, you too. Thanks, and give my best to Debbie, and we'll see you soon.
Focal Point AFR Talk will be right back. Stay with us.